Welcome back. We were talking with Tim Takacs, elder law attorney, about all kinds of things. Wills have been getting a lot of calls, interesting calls. Let's go to Forrest. Hello, Forrest.
Hello, how are you today?
Great. What's on your mind?
I would like for the attorney to explain the difference in per capita and per stirpes.
Oh, okay. You know, some of our favorite Latin terms.
Okay.
You know, now I know people laugh at lawyers because they say, you know, there's this Latin stuff, and we don't use a lot of Latin much anymore.
No.
But per capita and per stirpes are actually very handy terms that lawyers from time to time use. Per capita basically means, you know, that's a situation where, okay, we had the previous caller that says, well, mom dies first, you know, or my sister dies, you know, and then mom dies. Now, if the will says that I leave my estate to my children in equal shares per capita, that means that if one child predeceases, his or her share automatically gets divided among the surviving children. That's per capita.
Oh, so you just put in per capita.
You just put in per capita.
And then you're...
You know, and that's what that means.
Okay.
Per stirpes means that it, you know, if one child predeceases, you know, then that child's children, you know, inherit that child's share. Wow. That's the norm, you know, that's the default rule is per stirpes.
Okay.
You know, now, one of the things that, you know, and I talk about this from time to time, you know, when I'm, you know, talking to clients and on the show is that, well, you know, why do you have to keep using all those like Latin terms? You know, well, the answer is they can be very handy. Because, you know, I often say is that, you know, we're talking about the law has used these terms for centuries. Now, you know, here's little old me over here in Hendersonville, Tennessee, that decides that, well, I don't think I like that term, so I'm going to try to rewrite that.
Right, right.
You know, then suddenly, you know, you've got the rest of the bar and the judges and everybody else going, what was that idiot doing?
Yeah, what is he trying to say?
What is he trying to say here? Why didn't he just say per capita or per stirpes? Because everybody knows what that means.
Right.
You know, so sometimes it's actually pretty handy.
Yeah.
You know, and we're not trying to be, you know, we're not trying to make the documents complicated, or, you know, we're not trying to make them not understandable. You know, but we know that certain things work, you know, and so you, as we often say, is you deviate from those sorts of things at your peril.
All right, so there you go. I wasn't sure why he would ask that, but that's why. It's right on this topic of wills and everything. All right, Forrest, thank you for that. Thank you. Interesting call. Let's go to Ray. Hello, Ray.
Yes, hello.
Go right ahead.
Yeah, I plan very shortly to make out a will of my own and keep it really relatively simple. I wanted to leave everything in my possessions to my sister, and there may be one or two people that I want to name in there to exclude that I don't want to get anything, and leave the rest up to her as to who gets what or where it goes.
Okay.
But the main question about this is, does that will have to go through probate court to be executed legally, or just can the person that's made out to execute it without the benefit of going to court for it?
Okay, so remember what a will is, or how property passes from one generation to the next. Is one is it goes by operation of law. Okay, so you die, you know, and you own money or property, and it winds up going somewhere to children or other family members, or maybe you own property like jointly as husband and wife, so you pass away first. You know, it means your wife gets, you know, whatever you're owning jointly, it goes to her. That's one way. The second way is by a contract. So like if you have a life insurance policy, you know, or a retirement plan that has a beneficiary designation, that's a contract that you're making with the bank to pay these people. And the third way that property passes is by a written instruction. Okay, if it's a written instruction, somebody has to, you know, somebody has to make sure that that is bona fide.
Right, right.
You know, so you take it to a judge, and the judge looks at it and goes, yep, that's Ray's will. You know, and he's named the sister, his sister is the person that's going to carry out the wishes in the will. You know, and that's called probate.
That's all he needs. Oh, well, go ahead. No,
it's probate.
Okay.
You know, where she, you know, now he says, well, I don't really want probate, which I understand that, which means that what he really wants to do is set up his estate. So maybe he set up a trust so that when he passes away, his assets are in a trust, you know, and then maybe his sister is the trustee, and then that doesn't go through probate. Because that's a contract that he's making with a trustee that says, well, when I die, you know, trustee, you know, you're going to make these distributions of my estate, you know, under these instructions, and that doesn't go through probate. You know, so that's maybe what he's looking at. Now, hopefully, and Ray was talking about, you know, what was he saying is, well, I want to leave like a, I want to leave somebody out. Okay, don't give them $1.
Yeah.
Don't give them $10. You know, mention them if you must. You know, and if they are the natural objects of your bounty, which is like spouses and like children or grandchildren or whatever, you name them and you say, I have 3 children and I leave them nothing.
And I leave them nothing. Okay, we have to take a break.
Yep.
But that's how you do it. You don't leave them $1.
Yeah, because then you give them standing, and they are able to come in and like create havoc.
That's interesting. Yeah. All right, we're going to take a break. We'll be back. Wrap everything up right after this.